court liquidation process in Scotland. What is the liquidation process? The process of placing a company into liquidation via the court can be initiated by either its directors, shareholders, or by one of its creditors. You may have reached this situation with your own company if a creditor has been relentlessly chasing you for payment which the company cannot afford to pay, and its debts are greater than its total assets. Perhaps petitioning the court for winding up is the only remaining option. Typically, the first step will be for the directors to put a special resolution to the shareholders that the company be wound up through the court liquidation process. At this stage, they will need to consider who to appoint as interim liquidator and whether it is necessary to appoint them initially as provisional liquidator. It is necessary to instruct a licensed insolvency practitioner to oversee the matter. Middlebrooks helps businesses to deal with debt. We can help you determine whether liquidation is the right process for your company using our extensive professional experience and technical knowledge. Where to petition? If your company owes more than £750, you fail to pay or reach agreement to pay a 21-day statutory demand, or do not respond to a 72-hour winding up notice, it may be necessary for the company or a creditor to instruct a solicitor to prepare and file the petition. There are two options for where to present the petition: the Sheriff Court local to the company, the Court of Session in Edinburgh if the company's share capital is greater than £120,000. What happens when the petition is presented? Once a petition for liquidation is presented to the court and has been accepted, the petition will also be advertised in the Edinburgh Gazette as well as in local newspapers. Notice will be served on the company, and there will need to be a minimum of 8 days before the court will consider the winding up order. This is also the opportunity to appoint a provisional liquidator. They can be appointed where the company assets need to be safeguarded, there are perishable goods which need to be dealt with. The winding up order. After the expiry of the 8-day period, the instructed solicitor can go back to the court to request the winding up order be made. At this point, the interim liquidator will be appointed and take control of the company affairs. If a provisional liquidator has been in office, their appointment will come to an end when the winding up order is made. However, usually the provisional liquidator will become the interim liquidator. The interim liquidator will write to creditors to provide them with a report of the history of the company leading to liquidation, as well as details of its assets and debts, and seek their appointment as liquidator. Creditors have the right to choose a different liquidator at a creditor's decision process, or they can agree the continuation of the interim liquidator. A note will also be placed on the company's public record, as well as lodged with the Register of Companies and the accountant in bankruptcy. The main points to consider when facing liquidation are: the liquidator will take control of the company and be responsible for selling all of its assets. Creditors with security over the company's assets are entitled to be paid first and receive money from the proceeds of that asset's sale. Directors have no further control over the company. The liquidator is required to submit a report on the insolvency service re the conduct of directors upon their appointment. When liquidation is complete, the liquidator notifies the Register of Companies for Scotland and the AIB, and a notice is placed in the Edinburgh Gazette. The company is dissolved, generally 3 months after this notice has been placed.